Welcome to the 21st century. My name is George Bellis, and I'm going to try to introduce you to a few tips to help you survive in this changing environment. The world around us is changing. Technology is affecting everything in our society. Our children communicate with us differently. We now communicate with our children almost exclusively by text. Yet, the legal profession is the last business system to change. Recently, changes have taken over many aspects of our practice, and it's just not how we create documents or anything else. It's how we use evidence, and this requires us to use special consideration ethically in dealing with our clients. In 2006, the federal rules of civil procedure were changed to provide for how to deal with electronic discovery, e-discovery. They adapted a new term, ESI, electronically stored information. Those rules have been inundating us in a practice and affect how we practice law. Typically, the Illinois Supreme Court has been slow to make these changes. It was only last year that the Illinois Supreme Court changed the rules of practice regarding discovery and made some changes that conform our rules in Illinois to the federal rules. Recently, another big change to our Code of Professional Responsibility was announced by the Illinois Supreme Court. Lawyers are now required to adapt to changes in technology to best serve their clients. That means you have to be abreast of what's happening around us, what's happening in our digital age, and you need to adapt your practice. There were a series of cases in federal court called the Zubalaki cases. One of those cases is very significant for this discussion. That case indicated that lawyers have an obligation to take affirmative measures, be proactive in preserving evidence to protect their clients from claims of spoliation. It's really hard for many lawyers to accept the fact that in this computer age, we have additional responsibilities that we didn't have before. That means that we have to be proactive. We have to take measures to protect our clients from claims later of spoliation. There are a lot of reasons to preserve evidence or preserve documents. Business requires the preservation of certain evidence, and that is especially important when that evidence, that information is created digitally, because it can be lost easily, could be overwritten, anything can happen to it. But we have to make sure that our clients take the steps necessary to preserve those records. When you first meet with your client, you have to make sure that you affirmatively advise your client of the obligation he or she has or the business has to preserve information. I would strongly urge you when you first engage your client to put in writing an information to the client, notifying the client that the client must take measures to preserve information. This is particularly true in litigation. The client may not be aware of how digital evidence can disappear. So you have to advise your client immediately to protect and preserve information and evidence that you may need to prove your case. You may even want to go so far as to have your client's computer, especially this is true of individuals, make sure that your client's computer is preserved. I have taken steps in some cases to actually have my client's computer mirrored, which is a technology that gives you an opportunity to actually create an exact duplicate of your client's entire computer, and so you have it preserved exactly as it exists at that moment in time. Now you have to make sure your client also shuts up, which means especially in social media. You don't want your client, especially let's say a personal injury case, you don't want your client bragging that they're going out dancing and rock climbing when they have a claim in their case about a bad back. So you must admonish your client about that they must be quiet on social media and not talk about their case, and they must be affirmative in protecting the evidence that you need. Secondly, you must notify the other party in a litigation matter that there is an obligation to preserve information that you need for your case. So send out a preservation letter to your opposing party as soon as you know that litigation is going to commence. You must put them on notice of the lawsuit, or whether it's actually filed or not, that there will be a need to preserve evidence. Put the burden on them to control the evidence and preserve it. This is very important. And if you are going to file a lawsuit immediately, what I would also suggest you do is get into court as soon as you can and ask for an order from the court to preserve evidence that you need for your case. This is important. You must be proactive. You must make sure that the evidence you need for your case is preserved. Third, dealing with third parties is important, such as email service providers or storage facilities that your client's data is stored on. You should take measures immediately to notify those third parties. How about witnesses to your case, key witnesses, who may have email that you need to preserve? You must send letters to those third parties immediately. Now, email is a special subject, and you have to be very careful about how to do this. Email service providers such as Google, Gmail, AOL, Yahoo, they only keep their emails for a certain amount of time. You must take steps immediately to get that information, but you cannot get it without that party who holds that account's permission. So you need to get into court, ask for a court order directing the third party or the opposing party to sign a release so you could send that release to the email service provider and get that information. But again, it's very important that you be proactive in preserving the evidence that you need. And the key point to all of this is who has control of the information. That person has that responsibility to get the information, preserve it, and you have to put that control party on notice of their obligations. So, counselor, again, we're in the 21st century. New technology, the digital world, requires us to adapt to these changes in order to best represent our clients, and you have an ethical responsibility to do that and do it proactively.